Hello, this is Matt on the Moon Lambeau channel, and we have a bombshell revelation by attorney Jeremy Hogan regarding his analysis of the SEC versus Ripple suit, because Ripple the other day, in case you have not heard, has put out their preliminary response, approaching all of the allegations that the SEC put out in their original claim on December 22nd of last year. And it's at a point where effectively it's winner take all. It's Ripple is risking everything with the maneuver that they're taking. But here's the thing, I'm not trying to scare anybody by saying that. I think it speaks to the confidence that Ripple has. And so it was even surprising, this is attorney Jeremy Hogan even said he didn't think that this is quite the approach that Ripple would take. And so there's lots to cover here. I want to be clear that I don't have a financial background of any kind. I'm not offering financial advice, and you should not buy or sell anything because of anything that I say or write. I also don't have any sort of legal background. I'm just doing my best to kind of wade through the muck here. And I'm thankful that there are all sorts of attorneys out there that are willing to share their opinion. In this video, I'm going to be going through the opinion of attorney Jeremy Hogan of the law firm Hogan & Hogan based out of Florida. And there's an article about some content that he put out from Crypto News Flash titled "Ripple Makes SEC Lawsuit a Winner-Takes-All Game, Says Lawyer." And we are talking about Jeremy Hogan of this channel on the YouTubes, Legal Briefs. And I encourage you guys, if you have not yet subscribed to Jeremy's channel, it is absolutely fantastic. And with me not having any sort of legal background whatsoever, there's no way that I could share with you the type of insight that I'm able to in this video without the help of him. Well, specifically since this video is about his perspective, and I'll share with you my opinions on certain things. But and then there's also, like I said, a number of other lawyers that have really helped me to get my understanding to the point where I think that in all likelihood things are going to work out in favor of Ripple, but you still never know for sure. And that's why I always acknowledge it's riskier to hold XRP now than it was before. But it's not doing anything to shake my conviction. I'll just say that. And so what I did here is I've watched his video actually a couple times, and I took some notes. I usually don't take notes for myself because I just want my whatever is covered here. I do these videos in one take. I like it to be as like organic and raw as possible. But there's so many great points made that I didn't want to miss anything. So I've got I'm running this on my desktop computer, recording this here, but I have my my little convertible laptop here on my lap, and I got some notes here, so I'm going to be running through some stuff between the notes that I took, the actual filing of Ripple, the legal filing, and also this article here. And so, what's a good starting point? I guess I'll just look at my notes first. And so, Jeremy Hogan started by noting that the language in this particular filing, which is just known as the answer, it's just from a legal perspective, that's what this type of response is called, I've gathered, it's just called answer. And so you can see here it even states, answer of defendant Ripple Labs Inc. to plaintiff's complaint. And so Jeremy noted that they really tried to keep, and they did a good job of keeping what's in this document really free of technical jargon. And he cited, that the judge, she happens to be 61 years old and really just wanted to, keep things as lay as possible, at least in the tech realm. Obviously this is a brilliant woman, but from a tech perspective, like that's a whole different tech, area of expertise. And so this is just, something that Jeremy observed. And now I want to go down to page 5, section 10. And where am I? Oh, past it. Sorry, I was looking down at my screen here. Just 1 second. I apologize if I fumble and bumble a little bit more than normal in videos. It's just because I'm juggling a bit here, and I don't want to miss anything. And so I'm looking down at my notes, and then I'm also looking at the screen that's in front of me here on the desktop computer. Here we go. So check this out. Section 10. Ripple holds a large percentage of XRP, but that alone does not and cannot render it an investment contract. Many entities own large amounts of commodities and participate heavily in the commodities markets. Exxon holds large quantities of oil. De Beers owns large quantities of diamonds. Bitmain and other Chinese miners own a large percentage of outstanding Bitcoin. Such large commodity owners inevitably have interests aligned with some purchasers of the underlying asset, but there is no credible argument that substantial holdings convert those commodities or currencies into securities, nor has any case so held. And so to me, it's such an obvious thing. It's sad that this has to be stated, but this is, these are the charges that SEC has brought up. I think any human that's not halfway stupid can understand that the logic follows, right? It's just, it goes back to like Greg Kidd said too, it's like they think that we can't tell the difference between gold and a gold mine. So there's another analogy there. And so that to me is a strong argument. Now let's get to what Jeremy says Ripple's best legal argument is, and that comes on page 6, section 13. So let me get down here. Yeah, here we go. Check this out. The SEC's theory in the complaint would read the word contract out of investment contract and stretch beyond all sensible recognition the Supreme Court's test for determining investment contracts in SEC versus W.J. Howey Co. And so what we're talking about right there, I'm sure most of you, if you've been following this stuff, you're probably aware. It's known as the Howey test, and there are 4 prongs to this test. It resulted from this case cited here in 1946. And I'm not going to be going through that in this video. I've talked about that ad nauseum, so look at my older stuff, I guess. But I will say that there are 4 prongs to the Howey test. And in order for something to be a security, all 4 prongs of the Howey test must be satisfied. If even one of them is not satisfied, it is not a security, even if the other 3 line up perfectly. And so it's interesting when you talk about common enterprise, you get this idea of, if Ripple goes away, the XRP ledger and XRP itself continues to exist. And so that's a hard break right there. And there are other reasons too. I'm not going to go more in depth than that. But anyway, this section continues. Check this out. Because again, this is what Jeremy says is Ripple's best legal argument. Reads as follows. As a matter of economic substance, XRP categorically differs from the various instruments and business arrangements that Congress authorized the SEC to regulate, all of which, unlike Ripple, involve schemes devised by those who seek the use of the money of others on the promise of profits. Every other case in which courts have ruled that transactions involving a digital asset were investment contracts involved an issuer's ICO or other promise of future tokens to raise money to develop a digital asset product, as well as a contractual relationship between the issuer and asset purchasers. Ripple never held an ICO, never offered future tokens to raise money, and has no contracts with the vast majority of XRP holders. Ba-bam! That's like a mic drop moment right there. And in fact, to the extent that Ripple has sold XRP, it's been to strategic partners, never to retail users. They've never once in their history sold one single XRP to a single retail investor. Right. Next. I said this too, actually. So, in particular, it was the last 2 sentences. This is what Jeremy Hogan said was the bomb drop moment right here. Just the idea that Ripple never held an ICO, never offered future tokens to raise money, and has no contract with the vast majority of XRP holders. And so he noted the following. Here's a quote. How can you have an investment contract when you don't have a contract? It seems so simple, but, sometimes you just need to hear it worded like that from somebody that has a legal background, and that's exactly how Jeremy Hogan put it. He's making the complex understandable, which I certainly appreciate. How could we have a contract with Ripple as XRP holders when the XRP we hold might have been held by 100 different businesses or people previously? That's a point that Jeremy brought up, and it's a solid point. Who would we have a contract with? Ripple? Somehow? What? Doesn't make a damn bit of sense. And that's why, again, at the core of all of this, was there an investment contract? That's at the very core of all of this. The clear answer is no. And without there being an investment contract, XRP cannot be a security, right? And so here's a quote. It's like saying, I love this. This is good. It's like saying somehow, this is a quote from Jeremy Hogan. It's like saying somehow, my wife has a contract with the diamond mine in Africa that dug up the diamond that's on her wedding ring. Good luck with that one, SEC, which I thought was a great line. I got a kick out of that one. But it makes sense too, though, It makes a ton of sense. All right, next. I think I need to go to page 7, section 15. Where am I? Where's section 15? There we go. Okay, check this out. And the reason this is cool, before I even read this, it's because there is this recognition that because of the SEC's actions, there's been tremendous financial harm caused to XRP holders. This is the first legal document that even recognizes that, and it comes from Ripple. The SEC sure as hell didn't care. You know, where was the concern for XRP holders in the complaint of the SEC versus Ripple? Not a single sentence on that topic in what I believe was a 71-page document, if I'm not mistaken. They don't care. It's disgusting. Anyway, but check out this section. The complaint's overreaching allegations have caused harm not only to Ripple, but also to hundreds of non-parties that integrate XRP into products or offerings or otherwise support XRP, and to millions of XRP holders. It is especially important that the court rapidly determine the most consequential and overarching issue: whether Ripple's current distributions of XRP are investment contracts under existing U.S. securities laws. The answer is a resounding no, and reaching that determination quickly is urgently needed to provide clarity to the market. I tell you what, as an XRP holder, I could not be more appreciative of that particular statement. Now I need to go to page 8, section 2. Yeah, here you go. Take a look at this. So now we're getting to the part where it's response to plaintiff's allegations here. And number 2 reads as follows. Ripple denies the allegations in paragraph 2. That'd be of the original SEC document, except admits that Ripple did not file a registration statement for XRP with the SEC because none was required. And so you can see the direction that they continually go with this. Now take a look at page 9, section 9, because obviously, again, the direction, just to be clear, no investment contract, XRP is not a security. And just wait till we get to the bombshell moment here, as I was put by Jeremy Hogan here. So page 9, section 9. Ripple denies the allegations in paragraph 9. In that regard, Ripple has never offered or sold investment contracts in its distributions of XRP. Then to the next section. The allegations in paragraph 10 are legal conclusions to which no response is required. To the extent any response is necessary, Ripple denies the allegations. Ripple avers that it has never offered or sold investment contracts in its distributions of XRP. And by the way, I was not familiar with the word aver, so I did have to look that up on dictionary.com. It just means to strongly have an opinion. I feel like I got a pretty decent vocab, but I have never come across that word in my life that I can recall. But that is what it means. Avers, hey, we learned something new today. You learned something on a channel called the Moon Lambo channel. That seems unbelievable. How could that happen? All right, and then this is the fun part. Let's just get to the fun part. Can we do that? Got to go all the way down to like page 90. Almost there. This is probably the most fun part of the whole video, in my humble opinion. Yeah, here we go. Check this out. And so, I want to read that. Yeah, and part of this was covered in the Crypto Newsflash article, so I am going to jump over in a moment and cover some of that article. I apologize if there's a little bit of overlap. I did my best to kind of coordinate what I had notes taken up versus what was in the article, but there's probably going to be a little bit of overlap, but, just, I don't know, deal with it. I don't know. I'm doing my best here. So the affirmative defense is something the defendant, in this case Ripple, of course, once ruled on. Affirmative defenses, right? And so note that, and here's the neat thing, and we've talked about this before. The SEC, in their filing against Ripple, is not requesting a declaratory judgment that XRP be deemed a security. They're verbally stating it's a security, but they're not asking a judge to declare it, to actually come up with a judgment that says, yes, XRP is a security today. Right? And so, and this is important because a judge cannot grant something that is not requested. So there is no world in which XRP is going to be declared a security as a result of this trial. And so why didn't the SEC want to touch that? Well, that just makes me think, this is my unprofessional opinion because I get no legal background, but it certainly makes me think that the SEC doesn't think that would be a strong position. It's either that or for some reason they don't want it to be declared a security for some unknown reason. I think it's just because they understand it's a weak position, and I keep highlighting on this channel that almost every single lawyer that will speak on this that is unbiased, like they're stating that XRP, there's no way today it could be declared a security. So I think that's why the SEC isn't going for that determination. So what's Ripple doing? They want that determination, and this is where it got very interesting from Jeremy Hogan's perspective. And this is something that, like, just reading through this document myself, I would not have been able to pick up on without the expertise that Jeremy Hogan has, because this is his career. And so check this out. This is where it gets super duper interesting. Ripple wants a full determination from the court that XRP is not a security. Think about that. Ripple thinks they can win this whole thing, and it's a winner-takes-all case. XRP will be in the clear one way or another after this case is complete, period. Because Ripple's demanding it, right? And so it's going to be addressed. And so that says to Jeremy, and it makes sense to me, that Ripple believes they have a very strong foundation to indicate and prove in court that XRP absolutely is not a security, and that there never was any sort of investment contract from between XRP holders and Ripple. And that's bold. And so, again, no matter what, for better or worse, because we don't know for sure what's going to happen, XRP is going to be declared a security or not a security. So that's why actually I got to retract part of what I just said. It was the case that since the SEC was not going after the XRP to be declared, there was no declaratory judgment requested. If it was left there would be no satisfaction in terms of like clarity of, is XRP security, is it not? And so I did misspeak a minute ago. I apologize. But as a result of what Ripple has put forth here, there will be. That's, if I understood Jeremy Hogan correctly, and I believe that I did. He said pretty flatly that one way or another, there is going to be clarity of the regulatory status of XRP after this case is all said and done. And so I don't know what that does in terms of like the likelihood of a having a settlement versus not having a settlement, but that's fascinating. So let's hop over now to this piece from Crypto News Flash, because there's some quotes in here I think I wanted to highlight. Here you go. Take a look at this too. And so Ripple filed a Freedom of Information Act, and I actually made a video about this recently, and they want to know why the SEC made the determination that ETH today is not a security, but XRP they're claiming is. And so check this out. Jeremy Hogan from the law firm Hogan & Hogan in Orlando, USA, commented on Ripple's response in a YouTube video arguing that Ripple's response makes the lawsuit a winner-takes-all game. As the lawyer notes, Ripple wants a quick decision, which is why they did not file a motion to dismiss. This has typically been done by Ripple in other lawsuits only as a hassle or delay tactic. In the SEC lawsuit, however, Ripple is waiving it in order to get a ruling as quickly as possible. In addition to the arguments that Hogan believes are very strong, he highlights two strategies within the response letter in particular that he calls brilliant. First, Ripple has filed a motion under the Federal Sunshine Law to obtain the SEC's informal opinion regarding Ethereum's classification as a non-security. According to Hogan, this is by no means a desperate move. And I highlighted that too. Like there are multiple articles that use the word desperate in describing Ripple do this, but that's because those articles were written by Bitcoin maxi trolls, and they're just trying to push a narrative that is untrue, and it's very disingenuous, but that's what they did. It's actually a very strong move. So take a look at this quote from Jeremy Hogan. If you listen to the SEC's legal arguments, Ethereum at one point was definitely selling securities as well. So why the proclamation in 2018 that Ethereum didn't sell securities? Ripple has seen a chink in the armor and is going for it. Who knows what they'll find, but this issue will put the SEC on its back foot. Very subtle, but very good. Ripple, make the SEC defend itself for once. Exactly. So I think it's a great move. And then they have this little subheading, Ripple makes the lawsuit a winner-takes-all game. Furthermore, Hogan, actually, let me skip a little bit further. I feel like I sufficiently covered that portion. I think I wanted to jump down to here. Yeah, actually, even though I covered it, so there's a quote here, and I just want to hear it. This is exactly what Jeremy Hogan stated. So the article reads as follows. As Hogan notes, the SEC avoided seeking a declaratory judgment that XRP is a security in its complaint. The U.S. Securities and Exchange Commission is only seeking damages and remedies that would affect XRP held in trust. Ripple, however, is seeking to do just the opposite with this affirmative defense. This makes the lawsuit a winner-takes-all game. And actually, you know what? I think I apologize. I'm going back and forth. It's just I'm juggling a bit here, and I did my best to map this up before hitting record. I promise here. But I did want to read this. So under affirmative defenses, it reads as follows. Ripple alleges, asserts, and states the following defenses as separate and distinct defenses to the complaint. By virtue of alleging these further defenses, Ripple does not assume any burden of proof, persuasion, or production not otherwise legally assigned to it. And so look at number 2, second defense, XRP is not a security. And this was the bombshell part. I just want to make sure I actually read this. Ripple did not violate Section 5 of the Securities Act because XRP is not a security or investment contract, and Ripple's distributions or sales of XRP are not investment contracts. No registration was required in connection with any distribution or sale of XRP by Ripple. And so for me, I've read comments like that throughout this document, and so I wouldn't have understood, not having a law background, that if it's under the section of affirmative defenses, it means that, oh, we're going to get some clarity. There's no way I would have known that. So thank you. If you're listening, Jeremy Hogan, I very much appreciate the time that you're spending sharing all this information with your subscribers. The vast majority of which, no doubt, are in watching these videos anyway. I would assume we're in the XRP community. It's helping tremendously, so thank you very much. So here's a quote from Jeremy Hogan on this topic. So, in effect, Ripple itself has requested the complete ruling that the SEC did not. Ripple is saying they want a full determination from the court that XRP is not a security. Ripple could have escaped this lawsuit with no such finding if it had wanted. And here it is raising the major issue itself. You see, I honestly thought, I assumed really, that Ripple would tiptoe into defending the lawsuit looking for a quick settlement, but I apparently underestimated Ripple's belief in its position. This affirmative defense shows that Ripple truly believes it can and will win, not just on certain offerings of XRP, but all of them. When I read the affirmative defense, I was like Morpheus in the Matrix. That's a good quote. I like that. And then he had a little clip of it in his video. So amazing stuff here. So, Ripple's confidence doesn't necessarily mean that this is going to go well for them, but I tell you what, I'm feeling rather optimistic about the whole thing. And even without a law background, I can certainly recognize how absurd the claim is that there's an investment contract between me and Ripple. Or you and Ripple. I have no contract with Ripple. What the hell is that? It's absurd on its face. And so it's a bold move by Ripple because they could have tiptoed around this, like Jeremy Hogan said, and maybe something like what happened with Kick Interactive would have occurred, where maybe Ripple pays a fine or this or that, and they have to they could still sell XRP, but they have to, fill out an exemption form, and maybe there's restrictions, like with the Kick Interactive, there was like a 45-day period where they had to give notice to the SEC. But then, the Ken token of Kick Interactive was allowed to continue trading on exchanges. So we thought maybe something like that might happen. But now it doesn't look like that's the case. Now it looks like either XRP will or will not be declared a security because Ripple demands it, even though the SEC didn't even want to touch it. So the fact that the SEC didn't want to touch it and Ripple demands it, that speaks volumes. It really does. So we'll see. I'm feeling good about this. I don't know about you guys, but I'm optimistic. There's no way to, again, I keep saying it, there's no way to know for sure how it goes, but I am certainly optimistic to this point. But I will wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.